have the knowledge of law before drafting any plaint. Like say for example, we have matrimonial drafts as well for say under section 9 of Hindu Marriage Act for restitution of conjugal rights or for the divorce as well. So petitions are there are two things: petitions and plaint. Plaint are uh, for the civil remedy, and petitions are also civil remedy, but um, there's a mere difference of you know structural thing. So moving on to the matrimonial draft as well, like it's the basic thing of every draft. Only the facts, neither the law and there should be not no evidence in the fact. Evidences are given. At Anik, if possible, kindly share the matrimonial draft if you have any. And one more thing to keep in mind is when you start drafting one thing, it will always take you three drafts to reach finality. Because in first draft, you will write it, in a hasty manner. It will not be aligned properly. Just let it sit for a night. Read it once again the other day. You yourself will feel the need of changes, and you will do it by yourself. So this is a kind of standard thing which that एक ड्राफ्ट में आप परफेक्ट ड्राफ्ट नहीं कर सकते हो. There will be changes again and again as per the circumstances. So here this is the petition for restitution of conjugal rights, right? So always you when you write a plaint or petition, always write the high of that particular code. Like principal judge is the highest authority of a family court. No matter whether your case will be listed under you know magistrate or something, but principal judge is the highest court. Same is for the court petition. When you draft a writ petition, you always mention writ petitions. I hope everyone is aware that it is filed in the High Court and Supreme Court of India only. So whenever you draft a writ petition, you write in the Honorable Court of Chief Justice of so and so court, along with accompanying judges. So that is how you draft something. In the similar manner, if we look at the petition of restitution of conjugal rights in the court of sub, this is the preliminary. You have to. This is one is mandatory thing in the court of so and so judge, family court, district, which is my this. Then Hindu marriage act petition and then HMA petition number or
Sir, your voice is breaking.
all right. In case of divorce, hello, am I audible?
Yes, sir, you are audible.
Yeah. So as I was saying, in a petition, there are the parties are called petitioner, the one which is instituting the petition, and another party is called the respondent. Similarly, in the case of a plaint or a civil suit, the first party which is instituting the suit is called the plaintiff, and the other party is called the defendant. I hope you are aware of this, especially the second years. Therein, after this, after mentioning the parties, name of the parties, you go on to write the heading, the purpose of the suit. Like it's kind of a subject, but you don't specifically mention here subject. You just need to write petition petition for restitution of conjugal rights under section 9 of the Hindu Marriage Act. so and so. Now, moving on to the next standard thing, which is mandatorily written in every plaint or every draft, it is most respectfully show it. You just need to write this. It's an inherited term which we are continuously using since the British era. So most respectfully show it. Then para wise, you need to start every para with that. Mani, can you please scroll down a little bit? So first, in the first para, definitely you need to provide the details of the party and everything. Matrimonial drafts are quite specific in their structure. These are drafted in a particular way. That marriage was solemn. You need to define where it was, when it was solemnized, at which place, date, and all these things. Then the second paragraph, you see this is a standard paragraph. It has to be mandatorily written in every petition related to marriage, either be it the petition for restitution of conjugal rights, be it petition for divorce, be it petition for maintenance. This thing has to be written. All right. The status, age, and place of residence before and after marriage of both husband and wife, and if there are children born out of their marriage. Starting from the fourth para, you see the again there are the facts of the case. You just need to put down the facts of the case. And Mani, can you please scroll down to towards the last, towards the end, 4 to 5 points. I'll kindly scroll down a little bit more. All right, as you have seen, the fifth line there was that this petition is not filed, is not presented in collusion with the respondent. Collusion meaning that साथ मिली भगत से साथ में मिलके नहीं किया है. तो मैलाफाइड वे में हमने नहीं पुट किया है. और there is no unnecessary and improper. These are the standard things you need to write in every plain petition, like just for namesake. They are not matlab these have become a standard over the time. So anyway, you have to write these, and also you need to put the jurisdiction of the court. Matlab, it is mandatory that you put the jurisdiction of the court in every plaint, that this court has rightful jurisdiction over this matter to entertain this matter. This is all about the matrimonial dispute. Yeah, in the 10th prayer. Thereafter, then there is prayer. That what do you pray from this honorable court? So in that prayer, you just need to write what you want from the court to pass in your favor a decree or something, or an order. So as you can read, in the view of the above facts and circumstances, it is most respectfully and humbly prayed that this honorable court may be pleased to grant a decree of restitution of conjugal rights under section 9 of HMA in favor of the petitioner, or any other relief, order, direction this honorable court may deem fit in the interest of justice and equity. So this and or wala line जो है, this is standard you need to follow in every suit, petition, whatever thing you draft in the court. उसके ऊपर you can write prayer has not to be in one paragraph or two pointers. It's not mandatory. You can write two to three मतलब prayers in a single prayer column, whatever you want in separate ways. All right, then petitioner through an advocate. After that, there is a verification. Verification is for the matrimonial disputes. Or like no, it's for every civil suit. Verification, and thereafter affidavit. Affidavit is nothing but an oath that all the facts have been true and up to the best of my knowledge. And this affidavit drafting will teach you at a later stage. These are the basic preliminary drafts that you should learn. Next draft, basic draft, I will be showing of the recovery of damages. For the recovery of damages, the civil suit is instituted under for recovery of damages, not only for damages but recovery of any amount. It is filed under Order 37 of CPC. I hope you all are aware about the code of civil procedure, there are orders and rules in the order apart, and there are sections as well. So for recovery, suit for recovery, see we have this draft with us. Suit for recovery under Order 37 of CPC. In the court of district judge, the one thing which I should mention here is, as here it is written in the court of district judge. So it depends on the jurisdiction of civil suit depends upon the amount you are claiming. So you need to find out the commercial value of, there is a pecuniary, there is pecuniary jurisdiction of the different courts in commercial matters. So if your recovery is related to a commercial matter, you need to find the pecuniary jurisdiction of your state, high courts and district courts. Like for example, Delhi district courts of Delhi have pecuniary jurisdiction in the matters related to rupees 2 crores and below it. And if your matter pertains to more than this amount, you need to approach the Honorable High Court. So as you can see, the first part is similar in the court of district judge, district so and so court, the name and Delhi. Suit number. This is a suit, the civil suit, so therefore suit number of 2023, whatever the year is. Then again, you write suit under Order 37 of CPC 1908. Herein, you can also elaborate a little further for recovery of so and so amount. ठीक है, इतना आप लिख सकते हो, and it has to be underlined in bold letters and all capitals, not in the brackets. You don't need to write these in. Actually, this thing will come after the party memo of parties. I don't know why in this sample draft it has been written in after this in the court of. So after the see, as you can see in the memo of parties, you have mentioned the name of the person or the company, and again versus another one, that is defendant, plaintiff versus defendant. Now, as you can see, suit for recovery of rupees so and so under Order 37 of the CPC 1908. You don't need to write this thing in the above part as it was shown in this draft. I don't know why it has been written in such a way. Moving on, most respectfully, Shobit, as I've already told, this is a standard thing. We have inherited this, and we are continuing to use it. Doesn't make any sense. And then again, moving, you need to describe and define the party, everything, that the plaintiff is a company constituted under Companies Act, or if it is an say an insurance company, then registered under the IRA, you need to put in the company number, CIN number or IRDA number. So these things you need to mention each and every detail. You should not hide the facts, relevant facts about your client or your company whatsoever, whoever you are representing. Address will come, and so then you go on to write the cause of action, like how you are eligible, or how you have righteous claim to demand an amount of so and so amount. So these all totally depends on your fact. Whenever you go for a draft, you just ask your senior, sir हमको अच्छे से fact बता दीजिए. Or what they will do is they will give you a case summary, or they will provide you something on which you will rely, and you go on to draft your plaint or something. These things, I think you can all read from this, or we will provide you the case material in the group itself. You can go through it once, whichever draft you need. Again, these are the facts of the case, that so and so date plaintiff raised a final bill. Moving on to the money, kindly scroll down. Yeah, on the, as you can see, paragraph number 12, the cause of action, which is really very important in a civil suit. The cause of action, you need to mention the cause of action in every civil suit. Reason being, the cause of action decides your period of limitation of certain things. For example, for giving you one broad idea, for immovable properties, the cause of action is 3 years, and cause of so the period of limitation is 3 years, and for immovable property it is 12 years, and it starts from the day in which on the day from which you get the notice of certain uh, default on the part of other party. Notice as in you come to know about certain thing that my this right arises against this second party, and you were not aware of it in the past. So once you get aware of it, and there's ample proof that you were aware of that particular thing, the period of limitation starts from that particular day. So thereby cause of action is, it plays pivotal role in your draft. You have to definitely write it that cause of action arose on certain date when the defendant defaulted on his payment, and therefore it is within the limitation period, and I am liable to claim my compensation. The suit is within the period of limitation. Again, you'll have to mention it after the cause of action only. And then the jurisdiction, again. Jurisdiction clause is, mandatory for all the suits. The value for this suit, the value of this suit. In the civil suit, what you do is when you file a civil suit, there is certain amount of court fee that is to be paid in case the case is decided in favor of the defendant. This has been done in order to stop frivolous cases being arisen and filed on the pretext of a claim and all. The fees, mandatory fees, is because if you have a righteous claim, then you shall put certain amount of fees, deposit certain amount of the claim amount with the court, so that if it goes against you, if the case is decided against the plaintiff, then that particular amount is awarded. Not always, but it may be awarded to the defendant for their legal expenses and all. So it is just put up for saving the time of the court, and to check whether there are no frivolous cases filed. बिकॉज अगर आपको कोई क्लेम करना है 7 करोड़ का, आपने जाके हाई कोर्ट में फाइल कर दिया, आपका कोई क्लेम बन ही नहीं रहा है, तो फ्रिवलेसली सेकंड पार्टी को परेशान करने के लिए यू फाइल्ड अ केस. तो इन दैट केस यू विल एटलीस्ट हैव टू डिपॉजिट सर्टेन अमाउंट ऑफ फीस विद द कोर्ट बिफोर फाइलिंग अ सूट, or else your suit is liable to be rejected under Order 7, Rule 11 of the CPC. The other party can file rejection petition within the suit if you have not paid the fees in the first place.
Sir, voice is not coming.
So you're not audible.
Oath on paper that yes, I am stating truth relating to the facts and circumstances of this case. Am I audible to everyone?
Yes.
Yes, sir.
Token amount. No, it's not a token amount. It's called the court fees, and it is applicable in every civil suit or commercial suit you are filing. All right. So these are your preliminary drafts, which I think it will be required in your internships. We will provide you details of the case, and along with it, we will provide you a sample draft on the line of which you need to draft your you need to complete your assignments. And I can also, go for the rates and SLPs, but I don't think it makes sense at this stage for everyone to understand about those things, because there are quite, when you go to the high courts and Supreme Court, there are too many technicalities involved in those things. You need to mention the ground separately. Like there's a three times rule. I'll just give you a synopsis of it. There's a 3T rule. Like three times your fact shall be repeated in a SLP or a writ when you're going to the High Court or Supreme Court. there is a synopsis which has been formed. Synopsis में आप पूरा अच्छे से अपना केस छोटा सा बता दो within 2 or 3 pages, not more than 4 pages. Shall not take a synopsis shall not take more than 4 pages. It is a huge matter. After that, you need to go on to draft your plaint. Therein you will repeat those facts, and then on in the grounds you will reiterate your stand, your contentions. So this is a 3 times rule. Your facts will be repeated thrice. This is specifically for writ petitions and SLPs, especially petitions of in the Supreme Court. So yes, this is all about drafting. Just remember, just draft as per your knowledge. मतलब whatever command you have over your language. There is no hard and fast rule that you need to use legal words, don't know, legal maxims more and more, and just don't get subverted by the drafts of saying the advocates which are so fluent in English. उनको देख के लगता है कि यार हमारा ड्राफ्ट कुछ नहीं है. Just don't ever think about it in such a way. Start from basic things. Start storytelling. Draft is nothing but a storytelling to the court or to the other party. So the way you put your word, the way you align your paragraph, the way you align your story, it it leaves a huge impact on the court to understand your contentions and to deliver the judgment either in favor or against. It makes an impact. So yes, this is all about drafting. If you have any questions regarding this, you may ask, because I'm not emphasizing more on this because most of you are first year students, very few are second years as well. And on the later stage, when you do your physical internships or whenever we will provide you an assignment, you will learn through that assignment only. Because drafting is a thing which you cannot remember by heart, or you cannot do rote learning of a draft. You learn in the process. So therefore,
Sir,
I
will you please
find that
explain the point 12, what it's all about?
point 12 regarding the cause of action.
Yes, sir.
Cause of action is the time when your right accrues. आपका right कब बनता है किसी चीज पे. Suppose there is an agreement between two parties, you and me, and you need to deliver me something, and I have to pay a certain amount in lieu of that. And what happens is, you have delivered me the items, I have received it, but and I promise to pay that within a month. I'll pay you the remaining amount or whatever amount is due on. Then after a month, when the date arrives, I did not make the payment. So that day, that very day on which I defaulted, is the cause of action which arises, which accrues a right in favor of you. उस दिन आपको पता चल गया कि मेरा ये पैसे नहीं आया है और मेरा यहाँ पे अब राइट बन गया है लीगली उससे लेने का. आपका राइट तो पहले से था. राइट जैसे ही आपने सामान डिलीवर किया, योर राइट टू रिकवर मनी वाज देयर. But legally, as per the contract, your legal right arises on the day which I defaulted my payment on. So this is the cause of action. Cause of action for it can be multiple. There can be multiple cause of actions depending on the case of facts of the cases. Like for example, you say in case of defamation, there might be multiple cause of actions. A particular person is speaking ill about me in a public and then printing about me, and then on the social media posted something. So there are three cause of actions. It can be continuing as well. Like continuing cause of action is something. Say you are a resident of a welfare society and you are liable to pay a certain amount of fees, maintenance charges every month. And in case you are defaulting continuously on that payment, say for more than 3 or 4 years, then the cause of action is continuing on every default. But for the recovery, as I've already told, for the immovable property, like for money, the cause of action is 3 years, and you may claim the recovery of damages for many years, but the court will most probably allow only for 3 years in case of immovable property. So this is the cause of action, the day on which your right accrues, your right arises.
So you also said something about limitation.
Limitation you will learn in CPC only in the third semester of law faculty. I'm speaking particularly. You have this subject CPC and limitation. You learn about the limitation period and all these things in your course.
So basically, mentioning the cause of action in the notice determines the period of limitation.
In the notice it is not mandatory to write the cause of action. As I've already told, notice does not serve as a legal document. Like it does not hold a evidentiary, like primary evidentiary value. Notice is something to intimate the other party, unless it is mandated by an statute that a notice shall be served before instituting a suit, as it is specified in the under the Negotiable Instruments Act. Until then, it does not, serve the purpose of an evidentiary value. It's just, and also the Rent Control Act of Delhi. It mandates to serve a notice of 2 months before eviction and all these things. So until and unless it is mandated by a statute, it does not serve an effective, or you cannot call it as a primary evidence. Of course, it is an evidence, it is a documentary evidence, but not an primary evidence. There is a difference between both of them. So in notice, you don't need to write the cause of action. You just mention that you have defaulted on such and such date, and now you are liable to pay me. So notice is just a legal way to, or through an advocate, it is a way to demand your money. Just as simple as that. Either you write a letter by yourself कि भाई मेरा पैसा दे दो, that is a letter, or if you go through an advocate, it is a legal notice. That's the mere difference in that. Legal notice is nothing but a letter, but yes, being an advocate, it should be refined, it should be, aligned well. So this is the only difference. Any other questions? Most probably Rohit sir will be joining us tomorrow in our session, and he'll be explaining you the other relevant facts and regarding this legal drafting. And as I have said, that drafting is the thing which you learn over the course of your practice internship. Because being an advocate, I am also, learning so many things in the field of drafting as of now. So it's an ever learning process. Things are changing, and acts change as the way of presenting facts changes. So it's an ever learning process. And there is no hard and fast rule to draft a particular petition in that particular manner. Any other questions?
Good evening, sir.
Good evening.
So actually, I was asking, then when will our internship formally start from? Will it start
It
from tomorrow, or will it be starting when you will be giving us assignments or by communicating that through?
See, it will start from tomorrow itself. We have already, prepared assignments for you. So most probably you will be assigned a task by tomorrow itself or in the coming days. But it will start from tomorrow.
Okay, sir. The assignment would be given in a group, or it would be given individually to everyone.
Individually.
Okay, okay, okay. Thank you so much.
Our purpose is to you make you an independent lawyer, not a group lawyer. So
Yeah,
individually.
that's good, sir. Thank you so much.
Thank you, sir.
From the link, sir.
Yeah, yeah. Hello,
Thanks.
do you have any? Okay, if you don't have any other question, you can. If it arises in a future, you can just directly text me.
So there was a mention of Supreme Court visiting. Will there be any?
Yes, of course, definitely after the this internship ends, or maybe during the internship period, we'll let you know about it.
Okay, sir. Thank you.
Please send the group link. Type of drafting, as in like, uh, just give me a moment. There's no particular type of drafting. Like, how do you differentiate how do you categorize? It just depends on the different act. If you categorize it on the way, on the, in accordance with the act it pertains to, the act type changes, like a matrimonial draft, a recovery draft, a civil draft, a criminal draft, a bail petition. So type as in how you are, categorizing it. It depends on that. There is no particular type of drafting कि हाँ ये इस तरह से होता है. As far as I understand the type that person is asking for. If he has any particular connotation about the type, then kindly speak up and I'll explain in that particular manner.
Sir, suppose a woman want to file for domestic violence, dowry, and uh, also divorce, then we have to
Uh,
file three application, three application, or we have to do in the single draft.
you have asked for dowry, divorce,
Yes, sir.
and
Domestic violence, sir.
domestic violence. All right. So in domestic violence is a criminal offense. You need to file a police complaint, and the state will take the action on as per the DV Act. Right. For dowry is also a penal offense. You file a police complaint along with the DV Act. The state will take the action. You can, along with your advocate, file a petition, file a, you know, complaint, an application in 156 3 CRPC if police does not take any action. This is the preliminary step in divorce and DV Act, DV cases. As far as the dowry and DV cases. As far as the divorce is concerned, there are certain grounds of divorce enumerated in section 10 and 11, I guess, of HMA and other grounds as per the specific laws of that particular religion. So, as per your ground, you need to draft your petition. If it is by mutual consent, then both the parties are petitioners. There is no respondent. And if you are seeking divorce on grounds of cruelty, and so this is a criminal aspect and you need to prove it, that something like that has happened to me and I'm seeking divorce on this ground. So I hope I'm clear on this point. I make you clear on this point. If you have any further questions, you may ask.
तीनों अलग अलग हो जाएंगे, सर.
Yeah, exactly. See, अगर आप पुलिस कंप्लेंट फाइल करते हैं तो डॉरी एंड डीवी एक साथ कर सकते हैं. वो
Okay, sir.
क्लब हो जाएंगे दो चीज. And divorce is a different thing. Divorce, see, DV, domestic violence, and demanding of dowry, it all amounts to cruelty, and cruelty is a ground for divorce. So divorce petition is a different thing, and these cases are these two, dowry and domestic violence are the criminal aspects.
Okay.
फैमिली कोर्ट में नहीं चलता है ये मैजिस्ट्रेट के यहाँ चलता है.
So,
Any
hello.
other question?
Good evening.
Yeah,
Any
good evening.
specific format given for the drafting?
See, formats you will find in the case material, but these are not descriptive formats. It will be better if you are interning under someone, under an advocate. So you just ask them for the format. If they ask you to draft something, ask them to, provide you a sample draft so that in line of which you can draft your petition or notice whatsoever. If we will assign you something on which you cannot find a sample draft, we will provide you the draft on that. Don't worry about it.
And any font, even
Pardon?
any font.
Font. See,
Yeah.
standard font is of course Times New Roman, and the font size is 14. But I personally prefer Bookman Old Mark style in legal notices. Like in petition, I don't use it much, but for legal notices, yes, I use that font. It's my personal preference. In legal notice, you don't have any hard and fast rule that you use on a chair. It should be readable. That's it.
Yeah. Okay.
Sir, else other than notice while we draft things, so it is Times New Roman 12 and 1.5 line spacing, I guess.
Times New Roman 14. Font size should be 14.
Times
Yeah,
New
line
Roman
spacing. Line
14 and
spacing.
1.5 line spacing.
Yeah, 1.5. It totally depends on the type of draft you are in. Yeah, boom.
सर लीगल नोटिस जो लॉयर दे सकता है या आदमी खुद से लिख सकता है मतलब बिना लॉयर के?
Please one at a time. Please one at a time. Personally, please one of. Yeah, Shubham. Shubham, kindly repeat your voice. You are again not audible. Just drop a message. Just drop a message. The thing regarding the thing related to your font size and styling and margin and all. Shubham, you are not at all audible. Just drop a message in the chat box. Is it audible to anyone else? या मेरे को ही नहीं सुनाई दे रहा.
Sir is not audible.
Not audible at all.
Shubham, just drop your text. So the thing I was saying about this margins and alignment, you will eventually learn when you do things. है ना? So that's why I have not elaborated on that aspect, technical aspect of Microsoft Word, because everyone is not well versed with the softwares and all. And moreover, maybe tomorrow in a formal session or in the future, you will get to learn all these things. Any other question?
सर लीगल नोटिस अगर पैसे की रिकवरी के लिए लॉयर द्वारा ही भेजना चाहिए या आदमी खुद से लिख के भेज सकता है
आप
दूसरे
भेजेगा
पार्टी
तो वो
को?
लेटर कहलाएगा, लॉयर भेजेगा तो वो लीगल नोटिस कहलाएगा. ओनली डिफरेंस. आप खुद से लीगल नोटिस उसको लीगल नहीं बोल सकते ना.
Okay.
Legal notice is always sent through a lawyer. I hope there are no other questions, and if there are any, so just text me on the WhatsApp and I'll try to answer it as soon as possible. So I'm my first year. And
Sir,
tomorrow,
one more question is that, sir, जो नोटिस भेजेंगे वो प्लांटिव के बिहाफ पे भेजेंगे क्या या फिर द नेम ऑफ एडवोकेट?
notice will always be served on the letterhead of an advocate through an advocate from an advocate. Only you need to mention in the first paragraph that this notice has been drafted under the instructions of my client and on behalf of him.
ओके सर, थैंक यू.
और कहीं पे क्लाइंट का मेंशन नहीं होता. बस हाँ, अभी फिर नीचे फैक्ट्स में अगर आप लिखना चाहो कि हाँ जब कॉज ऑफ एक्शन आया होता है तो तब वहां पे तुम मेंशन करना है, दैट्स अ डिफरेंट थिंग फैक्ट्स में. बट वो जाएगा एडवोकेट के नाम से. दैट देन ओनली इट विल बी कॉल्ड अ लीगल नोटिस. I'm in my first year and do not know much about the sections in law. Can I? No issue, Shubham. If even if you are in a first year student, it does not mean you need to know about the entire law. You just need to know the particular section, and we will, definitely help you out in this thing as well. Don't worry, we will elaborate you before providing you any draft. All right, I hope there are no other questions, and if there are any, just drop a text on the WhatsApp or group or whatever by whatever means. We'll try to address it. Thank you so much for joining, everyone.
Sir, I
I
just
hope I was
have a small suggestion to make.
थैंक यू सर.
right. Yes, Hari, you were saying something.
Yes, I just have a small suggestion to make is that there are several organizations or institutions for this matter who offer courses